welcome to my Coolie Radio. Let's get it, because we gon' get it in. What's good, everybody? I hope everybody having a blessed day, and like I always say, stay sucker free. That's right, stay sucker free from these haters, because the haters is gonna hate. Let them hate, and that should make you motivate. Alright, that should motivate you to even work harder to your goals. Alright, make sure you download my Coolie Radio. Also, make sure you follow my Coolie Radio on all digital platforms, from iHeartRadio, Apple Podcasting, Podbean, all everywhere. Just put in my Coolie Radio and I will pop right up. Alright, also follow me on social media. Just put in my name, Mike Coolie, and I will pop up on social media on Facebook, Instagram, and YouTube. MikeKooly. Alright, make sure you push that notification so you can be notified on all my Coolie Radio segments when it comes. Alright, now I want you guys to understand something here. We're going to talk about Diddy. Yes, we're going to talk about Diddy some more. It's going to be a lot of segments about Diddy and up to his trial and all the way down. So buckle up. It's going to be a long, long ride. All right. Now, Diddy is going to be going to court, as you know, May. I believe somewhere in May. And we're going to see how this trial goes. Now, we're hearing that it's going to be some other indictments. Might come down the line. So we will see. All right. We will see. I'm going to sit here. We're going to get some more detail to you right now. I'm going to let you listen to a little bit of some people that I would love to listen to. Please follow them. It's Law Crime. All right. And they're very detailed about the case. And I want you to listen to this just a little bit. All right. I want you guys to listen to this and then to give you guys some detail. And then I'm going to come back and give you my opinion on it. All right. So I want you guys to kick back and buckle up here, and we're about to let it go. Here we go. And I will come back and give you my opinion.
For what we were calling a gag order, and I'm not going to walk out of court and do anything other than live up to that. We may be hearing from the attorneys for Sean Diddy Combs a lot less as we move toward a trial in his sex trafficking case. In court Thursday, we learned more about his defense team's push to exclude a damning piece of evidence. We learned about the trial date, the evidence found inside the hip-hop mogul's mansions, and the support that he's getting from his family. We got a full recap of the court proceedings and a lot more. Welcome to Sidebar, presented by Law and Crime, Jesse Weber.
So make sure you follow, alright, Law and Crime Sidebar with Jesse Weber, alright? Make sure you follow those guys. Those guys are very great at what they do and breaking down details of what's going on in the case and everything. So I just want to give you guys a little bit of the details from them, because they give so much great detail, just like I do. I want you to hear from them to give you more, a little bit of what's going on. Then I'm going to come back to you and I'm going to give you more. All right, here we go.
Well, it's been more than 3 weeks since Sean Diddy Combs, one of the richest and most influential rappers in the world, was locked up in New York on federal charges of racketeering, conspiracy, and sex trafficking. Prosecutors in the Southern District of New York say that Combs used that money, power to force people to do his bidding, with a heavy focus on what has been dubbed the freak-offs. These are described as elaborate, lengthy sexual performances that allegedly involved the hiring and transportation of commercial sex workers, the administration of drugs. Witnesses allegedly told the government that sometimes Combs would participate in these sex sessions. Other times he would just watch and pleasure himself. But these orgies were almost always recorded and saved, maybe for Combs to watch later, maybe for potential blackmail. Hey, so I know I always say this, but look, it is our privilege to be able to bring you these kind of stories, and I want to thank one of our great partners who helps make episodes like this possible, Upside. And Upside is actually the sponsor of today's Law and Crime YouTube takeover. Now, Upside's awesome. It is a free app that helps you get cash back on gas, groceries, food. It's real cash back. It's money that appears in your Upside app that you can transfer straight into your bank account. Super simple to use. For example, I used Upside to find a gas station. I claimed an offer. I paid at the pump with my my credit card, and then I followed the steps on the app, and I got cash back. And you can use Upside at all different kinds of places, restaurants, convenience stores. So to find out how much you could earn, click the link in the description to download Upside or scan the QR code on screen, and use our promo code LCTakeover, and you'll get an extra 25 cents back on every gallon on your first tank of gas. Well, what we're going to talk about now is the fact that Combs and his substantial defense team, they were back in court on Thursday in front of yet another new judge, Arun Subramanian. He is going to be the judge presiding over Combs' trial as of now. And by the way, it is now scheduled for May 2025, which we're going to talk about. Now, I got to call this out. There's no recording equipment allowed in New York's federal courthouses. There are no cameras. It is annoying. Trust me, I can talk all about this. But anyway, that's why we haven't seen video of Sean Combs in court or heard audio of him speaking to the judge. But we did have a correspondent in the courtroom. We're going to hear that in just a moment. But here's another thing to note. A lot of people are asking, why didn't they discuss the issue of bail this week? Well, we know there was a petition filed for a third crack at it, but that is not with this court. That's actually going on simultaneously in the Court of Appeals. This is a higher court, the Second Circuit Court of Appeals. They're going to decide if Combs should be granted bail. Now, Combs' attorney, Alexandra Shapiro, filed a motion for pretrial release earlier in the week with the Second Circuit Court of Appeals, and Shapiro opened the motion by writing, "This case does involve extreme and unusual circumstances, but none that typically foreclose bail or warrant forcing Sean Combs to defend himself from a prison cell. What is extreme and unusual about this case is that Mr. Combs was detained immediately after he was charged, even though he has been in the spotlight his entire life, with many of his purported antics and episodes being widely reported in the press and known to law enforcement authorities. Indeed, hardly a risk of flight, he is a 54-year-old father of 7, a U.S. citizen, an extraordinarily successful artist, businessman, philanthropist, and one of the most recognizable people on earth. The sensationalism surrounding his arrest has distorted the bail analysis. Mr. Combs was not released pending trial, even though he offered to comply with restrictive conditions that would have prevented any conceivable risk of flight or danger." And talking about that, Combs, by the way, had offered a $50 million bail package, putting up his Miami home and his mother's home as collateral. He promised to stay in close contact with authorities, only speak to certain people. He even offered to have a third-party security team to monitor his house if he should be under home confinement. But 2 different judges denied him bail, so Combs has been behind bars since September 16th at the Metropolitan Detention Center out in Brooklyn. And one of the reasons that was cited for keeping Combs locked up is his alleged influence and reach, because prosecutors claim that Combs had engaged in witness tampering and possible intimidation. His legal counsel says that is not true. They concede he spoke with people about the civil lawsuits that he was facing, but say he wasn't aware that the Southern District of New York was investigating him, and once he did realize he was being investigated, the appeal motion says he made sure to stop contact with these people. The motion reads, although the government vaguely described contacts with 2 grand jury witnesses, it proffered no evidence of any threats or intimidation. The government could only state there were 14 total contacts between Mr. Combs and one witness and another witness who was contacted multiple times. Defense counsel explained these contacts involved no obstruction or witness tampering. For example, one witness contacted Mr. Combs, not the other way around. She reached out to Mr. Combs and told him, "I'm a grand jury witness." After Mr. Combs informed defense counsel, he was instructed not to contact the witness anymore and didn't. And Shapiro argues that the prosecution didn't meet its burden to hold Combs until trial. Days later, there was an update that was filed with the court saying it is hereby ordered that the motion for bail is referred to a 3-judge panel. The request for immediate release pending decision on the bail motion by a 3-judge panel is denied. The motion to seal is granted. So basically, Combs can't be released immediately. They have to wait until the judges hear the arguments and then decide on what to do. Now, there was no information provided when that might happen or when the case is going to be heard in court, but we'll continue to follow it. All right, so now we're going to talk about Thursday's hearing for Combs' criminal case. And again, he's charged with racketeering conspiracy, sex trafficking, transportation to engage in prostitution. The core accusation, again, is that Combs used coercion, intimidation, force to get people to participate in these freak-offs. So to talk about everything, I want to bring in criminal defense attorney Natalie Whittingham-Burrell, who I love having here on Sidebar. Her window is making her look extra angelic today. She was sent from the heavens to talk about Sean Combs. So good to see you.
See you, Jesse. Thank you for having me on.
Can we talk about the bail motion, the third bail motion? I want to start there before we even talk about what happened Thursday. Does he have a shot? I think his attorneys raised some good arguments.
I think they raised good arguments as well. Maybe this will be third time's the charm, because the difference between this bail motion and the prior two is that this one really does get to the heart of what the court was concerned about, which was witness intimidation. And so when you have this dangerousness assessment, it's not just a danger that you will harm people or harm yourself, but a danger that you will interfere in how they conduct the case. And those were good arguments. I did not know that after he found out that they were grand jury witnesses, he had no further contact with them, and that when the contact was happening, it was more in relation to the civil cases. I don't know how they're going to prove that up at the hearing, but that is a good rebuttal to the prosecution's argument that he was contacting grand jury witnesses, because it is unique that there's a civil and a criminal case that are multiple civil cases and one criminal case that are tracking along the same time frame. So it's a good argument. I'll admit it's a really good argument.
And it makes me believe that maybe his attorneys didn't have that full information when the issue of bail came out, but they've been speaking to Sean Combs seemingly every day or consistently about what's been going on, so maybe they got that information from him. I guess somebody might be looking at this and saying, you know what, they have a point. The government hasn't necessarily proven that Sean Combs was reaching out to witnesses or contacting them or intimidating, but the standard to get him locked up is lower. You don't have to prove beyond a reasonable doubt. I think it's clear and convincing evidence, right? So explain to our viewers, is it right that the government can lock somebody up just by making an allegation that they've been intimidating witnesses without proving it necessarily?
Yeah, so that's the difficult thing about these bond review hearings, and that all of us criminal defense practitioners have to make. And that is that the prosecution can't just make allegations about our clients without much proof other than the allegation, and the judge will then turn to us and say, well, what's your response to that? And that does kind of put us on the back foot where we have to prove something that's not our burden to prove, right? So it's a very low standard. They really just need to make the allegation, but many times when the defense can come with something to rebut it, that helps to kind of even the playing field. But the prosecution definitely has the advantage when it comes to pretrial detention of criminal defendants.
Okay, now I want to talk about what happened yesterday. And there's a lot to talk about. So this was at the Southern District of New York, again in front of this new judge, Arun Subramanian, and we now know when this case could go to trial. A date has been set, maybe I should say tentative date has been set for May 5th, 2025. That was what was decided on, with several pretrial conferences planned between now and then. Natalie, is Combs hedging his bets here? In other words, if he feels he can't get out of jail now and he doesn't want to be there, let's try to get to trial as soon as possible.
I think we should change this for criminal defendants depending on where they are. So a criminal defendant who is out a lot of the times is okay with things taking their time, doing full investigation, not rushing to the end of the race. Whereas if you're incarcerated, you're trying to get out of there as soon as possible. And so I'm sure that he wants the quickest possible date. However, given the amount of evidence that there is in this case, discovery, investigation that needs to be done on the defense side, I would gamble that May 2025 would be too early of a date for a case of this magnitude. It probably would take them longer.
Oh, I'll get to the discovery in a minute, but what happened? So he just came on the record, his attorneys came on the record, May 5th, Your Honor, this is what we want. What happens if the Second Circuit Court of Appeals says he's released pre-trial release, he's granted bail? Can he then turn around and say, that May date, I don't really want to go to trial in May 2025, May 2026? Can he turn around and push for a longer time, or is that going to look very transparent about why he's doing it? Because essentially, I've always said, I think he came to New York, I think he's been as cooperative as possible, because I thought he can make bail. I'll be on home confinement for 1 year, 2 years. I'll push this trial out as long as possible until I actually have to go to trial where possibly can get convicted. So what happens if the Second Circuit says he's granted pre-trial release? Can he turn around and say, you know what, I want to push the trial date longer?
Good cause to continue a trial, and good cause is a pretty low standard, but courts guard trial timeliness very passionately. So you don't want to make a transparent request of, I'm out now and I don't want to see this thing through, so can we move this to the next year? You have to have some other reason. Hey, we need this expert, this witness system available for the trial date. They're going to have to be a bit more artful than that.
I get it. And they could say, look, the discovery is more than we thought. Couldn't know that they can get an acquittal, because what's the end result? We're going to rush to trial where he might get convicted and sentenced to 20 years in prison. That's not good for them. So doesn't it seem like they feel confident in the case?